of IDT Committee, on behalf of IDT Committee of Chamber of Tax Consultant, I welcome you all to the today's very important webinar covering the topic that is related to Mumbai High Court decision on validity of Rule 89(4)B and 9610. Well, friends, I'm sure many of us, including me, were struggling on this issue, and we have been facing a litigation at a ground level, adjudication, and first appeal level. Ultimately, it's big relief to many of those cases because of them. Then on Mumbai High Court decision, of course, we have other High Court decisions also, but this is our own jurisdictional High Court decision. And for that, we have approached to Mr. Sridharan sir, who is a lead arguer, and rather he has argued this matter on High Court. Is in the case of Hikal Limited, and there are various other cases we have clubbed together. And this decision was pronounced on 11 September 2025, a speaking order, where Sridharan sir was on a lead argument. Immediately, we in the committee, we discussed and we got few requisitions also from our committee member to ensure that we have some kind of a meeting or webinar to whereby the issues can be dealt and explained properly. And immediately we followed up, or rather we inquired with Sridharan sir. He is always, as usual in past, so I was just telling, more than 2 decades in IDT committee, we have been benefit of taking a knowledge, advantage of his knowledge. He had been to our forum for various occasions. Not only that, from his team members also, we have a lot of people who have already been there. And Vinay Jain, in fact, is our committee member. So he has gracefully and readily accepted our invitation. And we are really thankful to Sridharan sir for having exceeded our request at a very short notice to address us and cover this topic in a detail. Well, friends, just for the information, on a short notice, and to get on a peak season that Jain Gokhale sir, President sir, was mentioning, we are almost 240 plus enrollment for this. So looking forward for a wonderful exposition. Well, our the show will be like sir will be assisted by his junior. Both of them will take us through the entire decisions and the nitty-gritties. And thereafter, if you have any issues, you can put it in a chat box, whereby Umang, our convener, will address it and at the timely, and thereafter our Sridharan sir will revert back. Before I formally ask Keval to start, I'll request our President sir. We are in our centenary year, and fortunately, we have our President Jain Gokhale sir also has joined. So I request him to give his words of wisdom for this. Gokhale sir.
Thank you. Thank you, Rajiv ji. And good evening, Mr. Sridharan and your entire team. I'm sure only one person is visible here, but I'm sure you've got a large team working with you. So thank you very much for acceding to the request made by our Indirect Tax Committee. As a president, I must first of all confess that I am a stranger to indirect taxes, and therefore I have hardly ever participated in any of the seminars, etc., in concern with indirect taxes, except last year I had occasion to contribute in some way on the accounting aspects of one of them. Nonetheless, I have heard a lot about you, sir, Mr. Sridharan. Your name sort of is surpassing only narrow confines of channelized taxation that we live in today. I had heard about your reputation. In fact, Mr. Jain, I think I have met once at one of our earlier seminars, and therefore it's a great pleasure to be with you. I will take up just a couple of minutes to mention to all the participants, because we are reaching almost a century. Some of them may or may not be members of the chamber. I would just like to emphasize that, as has been amply demonstrated by Keval and his team, the chamber is committed to spread of knowledge. If you see, perhaps the logo behind me is not clearly visible. I'll have to move out from there. Our motto is Dhyanam Param Balam, which means that knowledge confers power. And our motto has been that, and we have been always attempting to spread knowledge, because it is not something that we retain for ourselves. The attempt is that maximum number of professionals we are able to reach out to, we are making every attempt. And one of the special initiatives we have taken in this centenary year is to try and have outreach, because the old concept of Chamber of Tax Consultants being uh, a Mumbai centric organization has gone away. To begin with, 100 years ago, it was Chamber of Income Tax Consultant, or CITC. Very strategically, almost a decade ago, we dropped the word income tax because it no longer remained confined to direct tax. It has now spread its wings into not just indirect tax, but also into other areas such as corporate governance, Companies Act, accounts audit, etc. However, the name still continues as Chamber of Tax Consultant, which continues to be our focus. But the other shift which we are trying to bring in the centenary year is to involve as many people from outside Mumbai as is possible. And it is programs of this nature that will enable us to reach out. I'm sure some of you would be participating from other cities where we are just in the process of finalizing the rules for our branches. We already have functioning units which are called study groups presently at Hyderabad, Bangalore, Pune. Uh, we are intending that in the current year, we'll be reaching out to few other cities, especially in Gujarat and Maharashtra. Uh, so Baroda, Kolhapur, Aurangabad, Nagpur, which have got high court benches, we are basically trying to spread, because and to enable those members to participate, because a question would arise in their mind that how do we participate when the organization is holding lectures in Mumbai? So in order to meet their requirement, we have just completed refurbishing our office, which has now got a state-of-the-art communication center. We can do webcasts from there directly. Mr. Sridharan, of course, not being here, he is speaking from his office, presumably. But we can have any faculty come to the office of the chamber and we can do an excellent webcast or podcast from there. We are intending that members or other professionals across the country could join in, as I'm sure some of them are joining in today. But I would urge you that in order to remain updated, please take benefit of the special digital membership offer that we have made for the centenary year. It's a very nominal membership which gives you lot of privileges without ever needing to visit Mumbai. All the knowledge updates can be provided at the click of a link. So I would therefore urge all of you to take benefit of that. The stronger our community grows across the country, the better informed we are and the better we are able to serve the profession and society together. It is all the more important because these concepts, as I'm sure you'll be discussing, need to be understood from experts. These are not things that can be done so easily. So when we have the guidance of experts like Mr. Sridharan to guide us, it enhances our capability and knowledge. So I look forward to this session. Mr. Sridharan, one personal word of apology that since I had not factored in this program after a certain point of time, although I am a keen student of law, I always appreciate legal analysis. I may not be able to fully participate in this, but I sincerely thank you for being here to guide all our members and pass the baton on to Keval to continue with the proceedings. Thank you.
Rajiv sir, you are muted.
Uh, I'll now request our chairman Keval to introduce our today's faculty senior counsel, Sridharan sir.
Thank you, Rajiv sir. Of course, Sridharan sir does not need an introduction, especially for our CTC members. But for the non-members, who I would just formally request, I would formally introduce Sridharan sir. Sridharan sir is a co-founder of Lakshmi Kumaran and Sridharan Attorneys. He is a seasoned lawyer possessing vast experience and successfully litigated on important matters for nearly 3 decades at Supreme Court, various high courts, CESTAT, ITAT, and Sales Tax Tribunal. He has been instrumental in assisting courts in deciding important questions of laws in indirect taxes. He has been designated as a senior advocate by the Bombay High Court in 2011. Sridharan sir's practice includes direct tax and indirect tax such as GST, customs, excise, service tax, sales tax, VAT, entry tax. Sir has touched technically each of the tax laws that we have in India. During the last decade, he has particularly specialized in constitutional and administrative law vis-a-vis taxation. He has extensively read in detail the GST laws of UK, European Union, New Zealand, and Australia. And Sridharan sir has been a veteran lecturer for all the programs, not just by CTC, but other organizations like BCS, our institute, all other well-known institutions. Sridharan sir, on behalf of CTC, we really thank you for sparing your valuable time and addressing our members. Sir, I was fortunate, one of the fortunates to be in the High Court when you were arguing this case. And at that point in time, I was sure that this is one webinar which we should plan because the conceptual aspects that you have touched upon in these arguments were really grateful. Sir, without much ado, I would request you to take charge of this session, sir. Over to you, Sridharan sir.
नमस्कार राजू भाई शुरू करें
Yeah,
Yes,
please,
sir.
sir. Please, sir.
Thank you for all the excellent introduction. There's only a small, not a error. Sahil is my close colleague, okay, and he's not a junior, okay. He's my right hand, and whatever I had argued in High Court is entirely what he had conceptualized and prepared, okay, and he's with me today, okay. And I will also request him to, because he has studied in great detail, we know the areas where we were getting into difficulty, and in discussion with him only we sort out those core areas. We'll be discussing that. Okay. So I'm not saying it's because he's sitting next to me. It's very special to me, and rightly so. As Mr. Narendra Modi once said, that Amit Shahji is what he is not because of me, but because of himself. So Sahil is of that type. It's not because of me, it is of him. Okay. I want this topic is important and interesting. It's nothing to do with tax laws at all. Okay. So if Jayant Bhai is suggesting that he has not taken too much interest in indirect tax, then that excuse is not applicable to the present topic. It applies to any legislation. Okay. And we had argued this point in the Gujarat High Court also. That also High Court has taken a view in our favor. And Bombay Court judgment is more focused and articulated and better written in terms of clarity of the principle. Okay. I'm sure the principle laid down with the Bombay Court are correct and logical. It is not a case where you succeed in the semi-final, fail in the final. Okay. So we're waiting for next Sunday. If Pakistan comes in the match, what happens? So this is not likely to have that kind. Even if the revenue goes to Supreme Court, we have an extremely good chance of succeeding in the matter. Before we go into our discussions, subject to what Keval and others suggest, the audience can put in their questions so that we can see the trend of their thought and we can modify the sessions accordingly. Okay. And I have no, if you all decide to want to permit any audience to ask question then and there also, I have no problem. Okay. But that's for you all to decide. Okay. Sahil?
Sir, I will request participant to put question in chat box so that our convener will take it at a right point of time with our faculties. Thank you. Rather than disturbing them. Thank you.
No problem. The first question is a good question. Okay. And without any way, this thing, I request Sahil to start the matter. Okay, because he knows the matter thoroughly and same clarity and efficiency. Okay. I'm not shirking my responsibility, but I know my responsibility. Okay. Okay. Yes, Sahil, you start. Whichever way you want to present, you present. Only emphasize past and close, which is the most difficult concept. Kindly explain the concept, okay? And with respect, many of these practitioners are simply interested in case law. Don't show them any case law. Show them principles only, okay? With this, they can solve any number of matters. Proceed the way you want, gather your thoughts and calmly and coolly.
Okay. Good evening, all of you. So we will sequence our thought process under 4-5 major headings. So broadly, before we start discussion, I would highlight that what will be the sequence of discussion. So firstly, we would like to highlight that what is the rule of common law on repeal. That is when the statutory provisions are silent. What will happen in case of repeal? That is the first conceptual thing. What is the rule of common law on repeal? Then second, because common law on repeal says broadly, we will discuss it in detail, that once the rule is omitted, it has effect as if it never existed, and it would obliterates all the things which are pending. To overcome the common law, what are the statutory provisions enacted under the General Clauses Act? That will be the second aspect we will be discussing. Third, the way in which the General Clauses Act is enacted, the respective provision is enacted. If at all some case is not covered by the General Clauses Act, then what would happen? That is the third aspect. Fourth one, incidental aspect, is whether the omission of rule is also treated as repeal or not. And fifth, in case General Clauses Act is not applicable, what are the other means by which saving clause can be inserted? It can be in the statute itself, or it can be in the repealing provision, etc. So these are broadly 5 different topics which we will be covering.
So first you are saying what is the general principles applicable, what we call rule of common law. We'll keep aside General Clause Act for a minute. That's the first point you want to explain. And second, what is the effect of a repeal? Things get obliterated. Third, you are going to explain what modification is made by General Clauses Act. Fourth point, you said, if for any reason General Clause Act doesn't apply, what happens? And then lastly, even without General Clause Act, any special savings can be there. Correct. Okay. Yeah, please continue.
And one more aspect which is very relevant even after the judgment, that we will discuss that under the General Clauses Act, all pending actions would die. However, if there are certain proceedings which are passed and closed, then those proceedings are saved. So it is very relevant to discuss what is the meaning of pending proceeding and what is the meaning of transactions which are passed and closed. So that is the last discussion, that how do you apply this judgment in facts of your case.
This last point is the most important point and most difficult point, and I'll request Sahil to explain it fully. The rest of it, people are vague, some idea. I'm not saying in a wrong manner, some idea, but what is the precise meaning of the word past and closed, and what is the meaning of pending? Some confusion can keep in people's mind. Internet. Sahil will explain that, and that's the most important point and most subtle point of the whole discussion. Now, please continue.
So the first topic is what is the rule of common law on repeal. So the very first point is, under the rule of common law, the repeal of a statute will obliterates it completely as if it never existed. So say once a rule is omitted or once a statute is repealed, then in the eye of law, it will be deemed as if that section or that act was never enacted. That is the first principle. The next question is, what is the impact of such omission or repeal? So the second bullet point, what it says, that after the repeal, the rights, liabilities, or proceedings which are initiated under the law which is repealed, it cannot survive unless the proceedings is concluded before the repeal. So effectively, the only exception to repeal is if certain proceedings are commenced, prosecuted, and concluded when the law was in force, then those proceedings will survive. So in effect, what we are saying, that under the common law, if there is no statutory provision to the contrary. Once a section is omitted or an act is repealed, then all actions which are pending as on the date of repeal would die. And the logic is, the common law presumes that once the law is omitted or repealed, the parliament do not want that law to continue because of whatever reason. So it will be deemed for all purposes as if that law was never enacted, and that's why all pending actions would abate. That is the first aspect of rule of common law. Now, yes.
One word about this common law. Common law is unwritten law, judge-made law. Okay. In England, a judge-made law, which is not in the form of any act, is called a common law. Law of contract is a common law. Okay. Tort law is a common law. So common law means, broadly speaking, unwritten law, but evolved by judges. That's all. That's the meaning. Right.
So in England or even in India before General Clauses Act, to overcome the effect of repeal under common law, Parliament used to enact a saving clause in the repealing act. So effectively, for example, say after introduction of GST, Excise Act is repealed. Then GST Act would say that the repeal of Excise Act by this act will not have an impact for the proceeding for the past period. That is broadly what a saving clause would say. So in order to overcome the effect of repeal under the common law, which has an effect of abating all pending proceedings, the repealing act itself will have a saving clause, and by which pending proceeding will be saved. However, because of this, there was a need to insert saving clause in each and every repealing act. So if at all for some reason the repealing act missed to insert such saving clause, then the common law would come into play and all pending proceeding would abate. To overcome this and to make sure that common law is not applicable in case of repeal, Section 6 of General Clauses Act was enacted.
Standardize.
Now, General Clauses Act has two types of provisions. There are some provisions under the General Clauses Act which merely codifies the common law. That is the otherwise applicable common law. It is codified by way of General Clauses Act. There are certain provisions in the General Clauses Act which depart from the common law. Section 6 is one of the example where the General Clauses Act departs from the common law. As we just now discussed, under the common law, on repeal, all pending proceeding will abate. However, Section 6 of General Clauses Act would say that even in case of repeal, pending proceeding can continue. That is the broad idea behind Section 6 of General Clauses Act. Now,
so kindly note this very important point which Sahil Bhai mentioned. Section 6 of General Clauses Act enacts a principle deviating from or overriding the common law. I repeat, Section 6 is not merely copying the otherwise applicable law. Rather, Section 6 is disregarding otherwise applicable common law and enacts a provision deviating from common law. I'm just emphasizing. Sorry, I'm not disrupting your thought process. No, please go.
Now, the text of Section 6 says that when any enactment is repealed by way of General Clauses Act or by way of central enactment, then the saving contained in Section 6 will apply. So two important elements. Section 6 of General Clauses Act will apply for repeal of any enactment. Any enactment can be act, rule, notification, it can be anything. However, that any enactment has to be repealed by way of either the General Clauses Act or by way of central enactment. So, for example, in case there is a rule and rule is repealed by another rule, then Section 6 of General Clauses Act will not apply, because Section 6 of General Clause Act will apply only in case where repeal is by the Central Act. And Central Act is different than rules. It is different than notifications. So Section 6 of General Clauses Act will not apply in few cases. One is that when repeal is by way of delegated legislation, that it is not by way of a Central Act. Second, if there is a temporary statute and by expiry of time the statute expires, then also General Clauses Act will not apply. Because to apply General Clauses Act, the repealing enactment has to be a Central Act. So this is the second limb. So first limb we said that under the common law, the effect of repeal is to abate all the pending proceeding. Only things which are passed and closed will be saved. There is a departure from the common law under Section 6 of General Clauses Act. Section 6 of General Clauses Act saves the proceedings which are pending also. However, Section 6 of General Clauses Act will only apply in case where repeal is by way of Central Act. These are the three aspects we discussed.
Can you give me an example where the repeal is a state act or repealed act is a state act and repealing is a central act? So the confusion which crept in the High Court, what is central act? Just explain that point a little more slowly. Huh?
Yes.
Give an example of some sales tax act, will be income tax.
Yes. So let's take an example that there is a rule under CGST.
Act.
Okay. Let's take an example that there is a state act, say Maharashtra Taxation Act, something which is enacted in the state of Maharashtra, and there is a central act which repeals the state act. First question is whether Section 6 will apply or not. So as I said, two things are to be seen. First, what is repealed, and second, repeal is by what instrument. So first, in our case, as I said, what is being repealed is a state act. Section 6 applies for repeal of any enactment. Since state act is also an enactment, Section 6 applies to repeal of state act also. The second aspect what is to be seen is the repeal is by which instrument. So in the given example, the repeal is by the Central Act. So Section 6 of General Clauses Act will apply in case where repeal is by the Central Act, even if what is being repealed is a state act. So to check the applicability of Section 6, we need to see that first what is being repealed, it can be any enactment. What is the repealing act? That has to be a Central Act. If we change the situation, say
I give an example. Assume for a minute. Assume entirely hypothetical. It's totally wrong. It cannot happen. Constitution of India is repealed by GST Act. I'm giving a hypothetical example.
Correct.
Constitution of India is repealed with the CGST Act.
Correct.
Will Section 6 apply?
Yes.
Bolo, bolo.
Yes, Section 6 applies because Constitution of India is an enactment and it is being repealed by a Central Act.
That's all. Okay. Now, CGST Act is repealed by Maharashtra GST Act. Let us assume for a minute.
Correct.
Okay. In the second example, the old legislation which is being brought to an end is a Central Act. It is made dead by a State Act. Correct. Will General Clause Act apply?
Central General Clauses Act will not apply.
Slowly. Explain that.
Yes. So one is what we are discussing is a General Clauses Act which is made by the Parliament.
Finish that.
Yes. Under Section 6 of General Clauses Act which is made by the Parliament, the repeal has to be by way of Central Act. In the example given by Sir, the repeal is by way of State Act, that is by a Maharashtra legislation. Then Section 6 of General Clauses Act will not apply because repeal is not by way of Central Act.
Please continue.
Now, General Clauses Act is made by the Parliament. There are also General Clauses Act which are made by the state legislatures. So in Maharashtra, for example, there will be a Maharashtra General Clauses Act. In Gujarat, there will be Gujarat General Clauses Act and so on and so forth. Now, the Section 6 of State Act would typically say that when the act is repealed by way of by this act or any other state act, then Section 6 of State General Clauses Act may apply.
So if Bombay Sales Tax in 1959 is repealed by MVAT Act 2003, then
Maharashtra State General Clauses Act
will apply. Section 6 of Maharashtra. It will apply because MVAT Act is a state act. So what is to be therefore seen is there is an Act 1, Act number 2. Act number 2 brings to end the life of Act number 1. All you have to see is Act number 2 a central act. Act number 2 the central act, Section 6 of General Clause Act will apply. You don't bother if Act number 2 repeals the rule, state rule, central rule, etc. Then also central General Clause Act will apply. So what you have to see is the provision of law which brings to end the earlier law. If the provision of law which brings to end the earlier law is a central act, Section 6 of Central General Clause Act will apply. If the provision of law which puts an end to the old law is a state act like MVAT Act, State General Clause Act will apply. And with respect, this is a confusion many people have. Okay. So you are not to look at what is being wiped out. You have to look at what is wiping it out. Correct? Okay. Sorry for disturbing. Please.
Now the third limb of our discussion is what is the meaning of repeal and whether omission of a rule can be treated as repeal or not. So typically, so in case of so what is repeal and what is omission? So let's take an example that there is a Maharashtra VAT Act and there is a Bombay Sales Tax Act. By way of Maharashtra VAT Act, entire Bombay Sales Tax Act is repealed. That is one example. There can be another example that only one section of the act is omitted. The act continues, only one provision is omitted. A dispute arose that whether the omission can be treated as repeal or not. Because the text of section 6 would say that in case of repeal, what is the consequences? Then a question arose that what is the meaning of repeal? So Supreme Court in case of Raila Corporation has taken a view that omission would not amount to repeal. However, subsequently, judgment of Supreme Court in case of Fiber Board has overruled that observation and held that omission would also amount to repeal. Now, why this discussion is relevant? In case only one rule or one sub-rule is omitted, then whether the discussion we made on rule of common law and omission would apply or not, or whether section 6 applies or not, that has to be tested. So once, as I said, Supreme Court has clarified that omission would also amount to repeal. So even in case of omission, the common law and repeal would apply. Equally, section 6 of General Clauses Act will also apply if it applies because of language of it. So that is the first aspect. Second aspect of Raila Corporation is, as just now we discussed, that section 6 applies only in case where repeal is by way of central act. In case repeal is by way of notification, then General Clauses Act will not apply. That is the second, that is what Raila Corporation held.
Can you repeat that point?
Yes. So for the sake of clarity, section 6 of General Clauses Act, which saves the pending proceeding, applies in case where repeal is by way of a central act. In case where repeal is by way of a notification, then section 6 of General Clauses Act will not apply. Because section 6 of General Clauses Act would say that if any enactment is repealed by central act, then section 6 will apply. Since the repeal is by way of a rule, then section 6 of General Clauses Act will not apply. So that is what we usually say that section 6 does not apply to subordinate legislation. That is little inaccurate. Section 6 will not apply when repeal is by subordinate legislation. In case rule is repealed by an act, then section 6 of General Clauses Act will certainly apply. So if in a given case, say there is a GST rule, say Rule 96 itself, and by way of an act of parliament, say GST Amendment Act 2025, if Rule 89 is omitted, then Section 6 of General Clauses Act will apply, because what is being omitted is an enactment and it is being omitted by way of a central act. But in case same Rule 89 is omitted by way of a notification, then Section 6 of General Clauses Act will not apply. That is what RILA Corporation says.
Okay, very well, very good.
Now, the aspects we discussed, similar issue came up before Supreme Court in case of Kolhapur cane sugar. In Kolhapur cane sugar, the erstwhile Rule 10A of Central Excise Act was omitted in 1977. The dispute was that when the rule is omitted without a saving clause, whether the show cause notice issued prior to 77 can be adjudicated or not. Now, discussing what we just now said, Supreme Court said that one, in the case of Kolhapur cane sugar, the repeal was by way of a notification and it was not by way of a central act. That's why Section 6 of General Clauses Act will not apply. Second, there was no inherent saving in the repealing notification. That's why the rule of common law on repeal would apply, and that is all pending proceeding would die. In effect, the show cause notice which were issued before 1977 cannot be adjudicated. Now, one aspect during this discussion, I said that there was no inherent saving in the repealing notification itself. I would like to touch upon that aspect. So, first thing we said that the saving clause can be contained in the General Clauses Act. But if because of some reason Section 6 doesn't apply, say in case where repeal is by way of notification, then the repealing enactment itself can contain a saving provision. Say let's take an example that say Rule 5 of GST rule is being repealed by GST Amendment Rule 2025. The GST Amendment Rule 2025, while omitting Rule 5 of CGST rules, can itself say that except in respect of things done or omitted to be done, the Rule 5 is omitted.
Repeat again.
The amending rule.
Repeat the whole example. Very well said, very correctly said. Repeat it.
Let's take an example that there is Rule 5 of CGST rules. That Rule 5 of CGST rule is being omitted by GST Amendment Rule 2025. Now, GST Amendment Rule 2025, while omitting Rule 5 of CGST rules, can say that Rule 5 of CGST rule is being omitted except in respect of things done or omitted to be done. The last phrase, except in respect of things done or omitted to be done, is in nature of saving clause. And that saving clause can be contained in the repealing notification itself, because legislation is aware that Section 6 of General Clause Act will not apply when repeal is by way of a notification. The repealing notification itself can contain such a saving clause. So in Kolhapur cane sugar case, what Supreme Court noted, one, that Section 6 doesn't apply because it is a repeal by way of a notification. Second, there was no inherent saving in the repealing notification itself, which can save past proceeding. And that's why the common law on repeal would apply. So that is what Kolhapur cane sugar says. Now, to overcome the judgment of Kolhapur cane sugar, retrospective amendments were carried out both under the Customs Act and Central Excise Act. Till now, we said that saving clause can be contained in two places. One, General Clauses Act. Second, the repealing notification itself can have a saving clause. This is the third place where saving clause can be there. Both under Central Excise Act and Customs Act, a saving clause was inserted that even in case where rule is omitted by way of a rule issued under that act, pending proceeding will be saved.
Repeat again.
So in
Section 38 said,
Section 38A of Central Excise Act said that even after repeal of rule by way of a rule under this act, all pending proceeding can continue. So the saving clause can also be contained in a parent act under which the subordinate legislation is framed. So now we have three places where saving clause can be there. It can be under General Clauses Act, it can be under repealing notification, it can be under the parent act under which the subordinate legislation is framed. However, if there is no such saving clause, either under the parent act or under the repealing notification, and section 6 doesn't apply because repeal is by way of a subordinate legislation or repeal is by way of notification and not central act, then the common law on repeal would apply. That is, it will abate all the pending proceeding. Now, when the GST law was framed, the legislation was well aware about existence of 38A and 159A under the Customs Act. However, because of whatever reason, there is no similar provision under CGST Act or SGST Act, which saves pending proceeding in case where repeal is by way of a notification. So, there is no provision under GST Act itself which saves pending proceeding. As we discussed, that section 6 doesn't apply when repeal is by way of notification. Then the only third option left with the government to save the pending action is to insert such saving clause in the repealing notification itself. Because section 6 Act, so just to repeat, there can be three ways of saving pending proceeding. One is section 6 of General Clauses Act. Second, provision in the Parent Act. Third is provision in the repealing notification. Section 6 of General Clauses Act will not apply. That law is already settled because repeal is by way of a rule. 6 will not apply. As far as GST Act is concerned, there is no provision similar to 38A or 159A which saves pending proceeding. Still, there is an option with the government that when they repeal any rule, in the repealing act itself or in the repealing rule itself, in the notification, they can insert a saving clause. Now,
slowly,
we presented a list of notifications issued under GST Act after 2017, where the repealing notification specifically had a saving clause. That is, the repealing notification issued under GST said that so and so rule is being omitted or so and so notification is being repealed except in respect of things done or omitted to be done. So when the legislation wanted, they specifically inserted a saving clause in the repealing notification. And there are at least 50 notifications. 62.
As per the judgment.
So there are 62 notifications in which government specifically inserted a saving clause by way of a repealing notification.
In GST.
In GST. In case of omission of Rule 9610 and 89.4b, there is no such saving clause in the repealing notification. That is notification 20 of 24. So three things. One is Rule 9610 and 89.4b is omitted by way of a notification. That is notification 20 of 24. As we discussed, notification is not a central act. So section 6 cannot apply. Second, there is no provision under CGST Act or SGST Act itself which saves pending proceeding. So there is no saving in the Parent Act. And third, government could have saved pending proceedings by way of inserting a saving clause in the notification which omits 9610 and 894B, but government chose not to insert such saving clause.
So in 20 or 24, if they added, except respect things done or omitted were done, hamara kahani khatam.
Correct.
20 of 24, they did not write this.
Yes.
Okay.
So because there is
कब आया था note in 20 or 24? October में. Sometime in July, some party came to us. I said GST Council has recommended omission. It will keep quiet. I guess it will omit it without a saving clause करके. I said 2 महीने के बाद हो गया था. Okay.
So because all three methods of saving is inapplicable in present case. Section 6 is inapplicable, no provision in Parent Act and no provision in the repealing notification. The rule of common law will apply. And what is rule of common law? All rights, liabilities and proceedings under the repealed act will be extinguished except in respect of things which are past and closed. So that is what Honorable Bombay High Court held, that because there is no savings, the common law on repeal would apply and all pending proceeding would abate.
Yeah.
Now the important...
Sahil, before reading this, just explain this. What is the relevance of transaction past and closed and what is the meaning of it? Okay. Distinguish between pending proceedings, future proceedings, people who have already been convicted, sentence is being served out. Correct. Slowly.
Yes.
Now, after, kindly don't read the slide for a minute. Yes. Just listen to Sahil back. Okay.
Yeah. Okay. Now, as we said, what is relevant for the purpose of effect of repeal is the transactions which are past and closed will not be disturbed. However, if there are, in case where there is no savings, the transactions which are past and closed will not be disturbed. However,
let bygones be bygones.
Yes.
Bygones and bygones is limited to past and closed.
Yes.
If it is not past and closed, whatever bhashan again the last 20 minutes will apply.
Yes.
If it is past and closed, the earlier bhashan will not apply.
Correct.
You are going to explain what is past and closed. Please continue. Sorry.
Yes. Now, I think we can take one example under, say, criminal law, which may be easier for us to understand. What is the meaning of term past and closed? Let's take an example that theft was an offense when the offense was committed.
Say Theft Act 2000.
Yes. Say under Theft Act 2000. However, subsequently, say after 2 years, because of whatever reason, the Theft Act is repealed. And because of repeal of Theft Act
in 2002.
In 2002.
So Theft Act 2000 is there. Somebody committed theft on 2001. Theft Act 2002 is repealed in 2002.
Correct.
Section 6 of General Clause Act will apply. Correct. Because it's Central Act.
Correct.
Aage badhiye.
Correct. Section 6 of General. But however, if let's take an example that theft is a crime under some rule framed under the Theft Act, and that rule is repealed in 2002. And in light of what we just now discussed, Section 6 of General Clauses Act will not apply when repeal is by way of a notification or by way of a rule. And let's take a situation where there is no savings in the Parent Act or there is no saving in the repealing notification. So whatever discussions we made just now will apply, that transaction past and closed will not be disturbed. However, pending proceeding will continue. Now let's take 3-4 scenarios. One is theft is committed in 2001. In 2002, when theft rules are repealed, the trial is still going on. That is the first scenario. So when theft was made, it was an offense under the law. However, during pendency of trial, it is no longer a offense. It is no longer an offense.
And the rule omission is prospective.
Rule omission is prospective.
What happens to the thief?
Yes. So one, because the trial is still continuing and person is not already convicted and has been sent to jail, the judge, while deciding his trial, or rather the trial itself cannot continue, because as on the date of omission, it is still a proceeding which is pending before the court of law. So the trial is still ongoing, and because of omission of rule which treats theft as an offense, the person will not be treated as guilty even if the point of time when offense was committed, he was guilty under the law applicable
Under
then.
the rules applicable.
Under the rules applicable then.
Hmm.
So this is the first scenario where when theft was committed, it was an offense. However, during trial, the rule is omitted. Then person will be not be treated as guilty, because as on the date of omission of rule, the pending proceedings are pending. It has not attained finality. Now, another example.
A simpler example, if criminal proceedings are started after 2002,
Yes.
what happens?
Yes. Another simpler example, theft in 2001. However, the proceeding itself is initiated after 2002.
What
Now, since proceeding itself have not commenced, then even if it was an offense in 2001, no fresh proceeding can be commenced after the omission of rule. So that is a simple case. Now, third case, theft committed in 2001, tried in 2001, person has been sent to jail in 2001. However, against that,
now order has been passed convicting him.
Yes, order has been passed convicting him.
In 2000, before 2002.
Before 2002.
So session judge has passed an order sentencing him to jail in 2002. Yes. He got a bail in the High Court. Again.
Yes. Now in this, there can be two situations. One is he has filed an appeal against his conviction. Second, he has not filed an appeal against his conviction. In case he has filed an appeal against his conviction as on the date of omission, then his conviction has not attained the finality, because the matter is still pending before a court in an appeal or whatever statutory remedies available to that person. So even if the person is already tried, has been sent to jail, either released
sentenced.
or sentenced. Yes, person has been tried and sentenced, may or may not be released on bail. But if appeal is filed against his conviction, then because of repeal, he will be held not guilty of that offense. Because as on the date of omission, his offense or his trial has not attained finality. It is pending before court in appeal.
Very important point. So, lower court has convicted him. He had filed an appeal before the appellate court. During the pendency of the appeal, the rule is omitted. Then what happens? He will be set free.
It will be treated as a pending proceeding, which would await under the rule of common law.
It is irrelevant that the original court has passed an order and appeal alone is pending. That makes no difference.
Yes.
Okay. Right. Next example.
Next example, if person is already tried and sentenced, however, he has not filed any appeal against such conviction, the person is serving his sentence, then as per my understanding, it will not be treated as a pending proceeding, because no appeal per se against the conviction is pending, and he
or take Supreme Court has convicted him.
Yes.
So in 2001, offense was committed. Theft rules were in 2000. He committed an offense in 2001. The rule is omitted in 2002. Okay. In 2001, he was convicted for 3 years. Correct. 2001 to 2004. Supreme Court, final court, upheld his conviction in 2001. Correct. What happens?
Yes. So in case where final court has already convicted and there is no possibility of any further appeal, or as on the date of omission, there is no further appeal which is pending, then it will be treated as a transaction or a matter which is passed and closed. And then even after omission, the person will be liable to serve the balance sentence. So effectively, by all these 4 examples, what we say that in case proceedings are not yet commenced, they cannot be commenced after the omission of rule. In case proceeding has been commenced, however, it is a subject matter of further remedy provided under the statute. Say an appeal has been filed, or a writ petition has been filed before a court of law, then the finality of the order or of the sentence of the order in our case is lost, because that matter is sub judice, either in appeal or in writ. Then it will not be treated as a matter which is passed and closed. However, if in some cases the order is passed before omission and there is no further appeal filed, and perhaps the time limit to file an appeal also has expired by the time the omission comes, then it may be treated as a transaction which is passed and closed.
Even though he remains in jail for a period after the omission.
Yes.
Serving out sentence
Is
is not treated as a pending proceedings. I repeat, serving out sentence is not treated as a pending proceedings, it is treated as a past and closed.
Yes.
Everything else is treated as pending. Whether pending an appeal, etc., makes no difference.
Correct.
Yeah.
So
now read this slide.
I'll just read it what is written here. So Cray said that effect of repealing a statute is to obliterate it as completely from the record of Parliament as if it had never been passed. That is what the rule of common law, we said that as if it never existed. For all purposes, it will be treated as if this law never existed. So there cannot be any offense under that law, or there cannot be any breach of the law which never existed. Crawford says a repeal without a saving clause will destroy any proceeding, whether not yet begun or whether pending at the time of the enactment of repealing act, and not already prosecuted to a final judgment so as to create a vested right. So in case any proceeding has attained finality, either because of non-appeal or because it has reached to a Supreme Court where there is no possibility of further appeal, then it will be treated as a transaction which is passed and closed. Everything else would abate.
इसको बार बार क्यों एम्फेसिस कर रहे हो उसको past and closed लोगों को तंग करने के लिए what is the relevance of this explain.
So the relevance of this is practically there are various cases where show cause notice was issued before omission, it is yet to be adjudicated. There are certain cases where show cause notice has been adjudicated, appeal has been filed, matter is pending in appeal. There are certain cases where first appellate authority has already decided the matter against the assessee. Because tribunal is not yet constituted, appeal has not been filed. However, time limit to file an appeal is still available in view of recent notification till next June. There are some cases where payment is made.
वो छोड़ दो 2 मिनट के लिए. So therefore, if a show cause is being issued post October 24, कोई problem ही नहीं है.
Correct.
Show cause issued prior to October 24, it is not yet been decided by the commissioner, that also will go.
Correct.
Show cause has been issued prior to October 24, order has been passed prior to October 24, you have filed an appeal before Commissioner Appeals, it is pending, you will get relief in that. If show cause is issued prior to October 24, order has been passed prior to October 24, you went in appeal to Commissioner Appeals, Commissioner Appeals has dismissed your appeal, you are not have filed an appeal to the tribunal. Since time for appeal is not over, all you have to do is formally file an appeal, that also will go.
Yes.
Instead of going an appeal to the tribunal, you have filed a writ. Order is passed post, show cause issued, order is passed prior to October 24, you file a writ, now you will get relief in that.
Yes.
Okay. So that is the meaning. Only people who will not get relief is those orders which have been passed prior to October 24, which had become final, If you file a writ today, the court excludes the delay, no problem. If the court doesn't exclude delay, it may become a matter of past and closed. That's the reason we are explaining this, because this is the point where the judges were also wanting to know the full picture. Okay. That is all. Okay. Any other point we want to explain? It completes everything fully. Rajiv bhai?
Yes, sir. Yes, sir.
Sahil explained lucidly, no? Completely.
Absolutely. Not lucidly fantastic. It's absolutely clear. There are so many questions in a chat box. I think many of them during the talk Sahil has taken up. But anyway, Keval, you can take it one by one if it is missed out, so that the participant gets the clarity if at all he's still missing on that.
Just 1 minute. Just 1 minute. Just run through the questions. 1 minute. Same question. What's the difference? Explain. Okay. Just take the appeal not at file time is not.
So one of the question is that I think that is already covered, that in case Commissioner Appeal has already decided the matter against the assessee and the appeal has not been filed before the tribunal because tribunal is not yet constituted, such matters will not be treated as transaction passed and closed because time limit to file an appeal is still available. However, the person will have to formally file an appeal because the order still exists, and then in the
make the pre-deposit also.
Maybe denial of refund.
Jo kuch bhi ho.
Whatever. Appeal has to be filed by following whatever is provided under the statute. Procedure is provided under the statute, and then plead that since it was a pending as on the date of omission, this order should await.
Or you should come to me, I'll file a writ and make some easy money. Okay. So, those cases where Commissioner Appeal has already passed the order and you are not gone to the tribunal, you will still get relief. That's the first point.
Yes.
Then there's somebody says, what happens if the section saving clause includes retrospect in GST? Tab ke baad tab dekhenge. That will be subject to another webinar. Somebody has asked if the Parliament enacts retrospective amendment GST Act to put this saving clause, what will happen? You can have a problem. Then we have to argue. Okay. It can happen. If it happens, we have to re-argue. Then
I think somebody has raised a question that Section 6 applies to regulations also, and what is the meaning of regulation? So, under the Constitution, for the states, state legislation,
union territory.
For the state legislation makes the law, that is called as state acts. For union territories, the president makes regulations. So, for example, there is a Dadra Nagar Haveli VAT regulation, where there is no legislative assembly. There, the president makes the regulation, and for repeal of regulation also, Section 6 applies. So it has nothing to do with rules framed under that. Regulations are different.
The regulation is something framed directly under the powers vested in the Constitution. For example, for Dadra Nagar Haveli, the president is claiming the regulation, not in terms of provision contained in Dadra Nagar Act. Act itself is called regulation. Dadra Nagar Haveli regulations. That's what you call as VAT Act in other states, you call union territory as a regulation. And that is made by the president directly under the Constitution. It can also be made by the administrator, also directly under the Constitution. So when Section 6 refers to regulation, it is referring to those regulations. Not, for example, the Customs Act. Central government make rules and CBIC frames regulations. Okay. So that regulation is not the regulation referred to in Section 6 of the General Laws Act. And that regulation is also not a rule referred to in Section 6 of the General Laws Act. That's second. difference between State Act and Central General Clause Act. Somebody has asked the question, how does it make a difference whether it is Central Raj Namaskar? What is the difference whether it is Central General Clause Act or State General Clause Act? Nothing. It's more question of completion. If there is no State General Clause Act and Central Clause alone is there, then some cases you may succeed. So I was only giving a complete picture. If there are cases where a Central Act has been repealed by a State Act. British Parliament has made a law pre-1950 that falls post-1950 under the state list. The state legislature can repeal that. For that repeal, if I show you Section 6 General Laws Act, you chartered accountant lawyers are very clever. It says that this is not a Central Act. How will it apply? Then I have to answer such difficult lawyers also. For that, I say Section 6 the State General Laws Act will apply. Okay. Only to complete the picture. It's only a technicality. So the observation of the participant, it's only a technicality. It's correct, but we are on correct legal proposition. Then what else? Then we answer those questions. Go one by one by sequence wise.
Sir, you want Cable who has gone through this? Can he put you the question after going through chat box?
Sahil has gone through the questions. We have seen that.
Okay. Because some of
But
them
just-
may not be relevant to the topic also. That's
No,
fine.
that's okay. That we will see that, no problem. Most of the time, what I talk is never relevant to the topic.
No, sir, it's not
Today,
like
because Sahil spoke, everything he spoke is stuck to the topic. Okay.
If that is the case, Sridharan sir, if that is the case, we will never get these kind of decisions.
No problem. refund की बात कर रहे हैं ना वो बोलो ना क्या है?
The first is, I think I have paid tax and interest.
You want to show this question in the screen? I have no problem. Keval, first question.
Should I share my screen, sir?
Yes, anybody can. So everybody can see that quickly. You can also show the screen, no? Chat box.
Sahil,
Yes.
Sahil, you can see?
Yeah, everybody.
Yes.
Yes.
Sir, this one, as far as entry tax and the Haryana,
वो तो बाद में देखते हैं. Let us finish first. Refund की बात करना है. Yes. Go back to the earlier question. Keval, why are you skipping the first one? He has paid and interest he has got. Interest will be cost, a refund will be allowed. किसने पूछा था ये क्वेश्चन? पंकज अग्रवाल. आप पंकज को अनम्यूट कर सकते हैं भैया?
Yeah, we can do that, sir. He is Pankaj, you can unmute and speak.
Sir, good evening, sir.
Yeah. The question you asked at the beginning of the session, now that
Yes,
you have
sir.
heard Sahil fully, आप जवाब दीजिए ना?
हाँ सर, आई थिंक कि इंटरेस्ट का रिफंड मिलना चाहिए सर.
How to decide that?
Because of the reason that the rule was not existed on the first day, and it was a recovery which is not tax, and whatever recovery is not tax, the revenue cannot.
Yeah,
keep
only
on
question
with
to
them.
be asked is it a pending proceeding or is it a past and closed? आपको एक क्वेश्चन
It is-
पूछना. If your transaction is past and closed, कहानी खत्म. आपको you may get relief on some other ground. You may get relief that you have no authority to do that, etc., etc. That's a different matter.
Correct, sir.
But if you are to rely on this Bombay High Court judgment repeal and saving, एक ही बात आपको पूछना है. Is it a past and closed transaction or is it pending? If it is past and closed, no relief because of the bhashan you heard from me. If it is pending, you get relief based on the Bombay High Court. Now, only way, if you have to revive the matter, You may apply for a refund. You still have a problem. Somebody can say it become passed and closed. Okay. They may say it's passed and closed. Maybe if it is pending, if time for filing appeal is over, maybe different matter. You ask the authority to pass a speaking order, no problem. But you are not worse off by filing refund for interest if 2-year period is not over. If 2-year period is over, then you will not be able to get any relief. Okay. That's the first question.
Sahil sir, Sridharan sir, just
Hmm.
one point. When you say transaction passed and closed, now this decision has touched upon one more aspect is the Kerala High Court decision, where Kerala High Court had strike down the virus. And this court said we are not getting into the virus because we believe it is the omission itself takes care. Now, in case of past and closed, can we explore that option of challenging the virus? And more importantly, the court has also observed the Kerala High Court should apply across the country. That decision should apply across.
But that is true. But then, in terms of Mafatlal judgment, even if it is struck down, you have to fight your own battle.
Hmm.
Okay. You have to fight your own battle. Okay. And I am not sure about the correctness of the Kerala High Court judgment on that point. Okay. Right. The same question. Question 1 and 2.
Yes.
Then Manish Sachdev entry tax no entry to you करके. Keval and Rajiv have told me no entry to you on entry tax. So बाद में देखेंगे. आगे. We'll come back if time permits. The difference between ये किसने पूछा भाई राघव गुप्ता जी उनका अनम्यूट करिएगा.
Raghavji, you can speak.
We've asked him to unmute, I think.
He might have thought that heard the lecture for 5-10 minutes, felt bored, and did wisely exit from the session. Nothing wrong in that. I want to ask him whether he has now understood the difference. His questions stand answered or still remains outstanding.
Raghavji, you are there?
Yes, Raghavji is there. Raghavji, can you please unmute? We've allowed you to, we've given you the authority to speak.
Okay, let us go to the next. I think he's.
That's okay. हो गया वो तो. ये भी हो गया. Difference between omission and repeal पता ना भैया. साहिल भाई. Reiterate the difference between omission and repeal.
I think before.
पूछिए ना उनसे. वो राघव का है कि वो भी ये भी. Raghav Gupta has asked the difference between omission and repeal. वो है तो he can ask. Then this Karthik Goenka has asked, will review proceedings be considered as pending? Which is review? कौन सा review भैया? I not seen any review power of review in GST.
Sir, I think in that example you are giving now about the theft case where Supreme Court has already decided against. And there is
Okay.
a
Review proceeding can be. It can be. The test is, the word used is, if the court is in a position to modify the order of the lower court, then it is pending. So if in a review they can do so, no problem. Right. Then, if time limit is not over, certainly you file the appeal. Okay, sir, if an offence is committed but the relevant section was repealed, 2000 and no appeal has been filed, though limitation period filing is still open. But he can file an appeal, he can file the appeal and get the matter quashed on the ground.
Yeah, this was dealt with.
No problem. Yes, Advant Gokhale asked a correct question and Sahil Bhai explained also. If 9610 has been omitted by any central act, CGST Amendment Act 2024, then all this point escape route would not be available to you. I repeat, you had a narrow escape route because rule was omitted by a rule. if the omission has been done by GST Amendment Act, then Advait Gokhale's point is perfect. Section 6 would have applied and we would not have got any relief. The point of importance is what is being wiped out may be anything. What wipes it out should be a central act. Then Section 6 of the General Act Clause Act will apply. What wipes it out is the State Act, the State General Clause Act will apply. Itni si baat hai. Okay. There was some confusion in the court on this. Once we clarified that, everything fell in place. Yes. Yeah. This question you should answer. Whether can I get a recording of the lecture?
No, we'll share the recording definitely, sir.
Okay. Sir, what is the status of anti-profiteering section 171 after 31st March 25? किसने पूछा ये? Ashwin Thakur. Can you kindly unmute him, please? March 25 में क्या हुआ?
Sir, it is more so to do with the rate changes that has happened from yesterday.
Hey, what is the status of anti-providence section of 171 after 31st March 25? So,
No,
is
no.
Ashwin Thakur, is he on the line?
Yes, he's there. He's unmuted.
Hello.
Yes, sir.
Good evening, sir.
Ashwin bhai, what happened? What happened on 31st March 25, bhaiya?
Actually, they are saying that the anti-property application will not accepted by the anti-property authority, but section is there. So can the government take the step on the anti-property?
मैंने आपसे इतना ही पूछा 31st March 24 क्या हुआ? What happened to the section? Is there anything in the section saying this section remains valid up to 31st March 25? So the question asked you is, what happened on 31st March 25? Whether an amendment act introduced or the original section says this section will die on 31st March 25. There's a legal reason why I'm asking you.
No, no, sir.
The authority constituted was wound up on 31st March 25. मैं ही पूछ रहा हूँ आपसे. The reason why I'm asking you to help you to find answer yourself. Okay. What happened on 31st March 25? बोलिए.
Anti-property application will not accepted by the anti-property authority.
Right.
But the section is there.
Now my question is, suppose right in 2017, 171.1 is there. 171.2 was not there at all. शुरू में 171.1 was there, 171.2 वगैरह नहीं था. तब क्या होता है? What would have happened?
They can take the actions for anti-profiteering.
There is a section which prohibits you from doing. There is no remedy provided in the GST Act itself. So ordinary civil courts can do, or some penalty section can apply. You may not be asked to pay back the amount to the government or transfer to the consumer welfare fund.
Right.
So the problem is nothing to do with the authority vanishing. If 171.1 alone was enacted, then the consequence would be that for breach of 171.1, penalty may be levied under the Act. Parties can go to the consumer forum or file a civil suit claiming refund from you. They can do so. Okay. If neither of them is done, 171.1 is remaining on the statute book. There is no remedy for the aggrieved consumer. Okay, that's all. So that remedies will continue to apply. Okay. If 171.1 has expired on March 25 and Sahil bhai explained expiry is not repeal, section 6 will not apply. So why I asked you was what happened on 31st March 25. If original 171.1 said this section will remain in force up to and inclusive of March 25 and it died by efflux of time, then section 6 would not have applied. That is not the position. What happened on 31st March 25 is authority was not there, no fresh application will be admitted. But your liability under 171.1 continues. What's the liability under 171.1? Penalty may be there. Suit can be filed against you. Okay. The separate machinery provided under the GST Act itself was not up. That's all. Okay. Right.
Okay, sir. Thank you very much.
Yes. Rajiv bhai, this question on interest out of
Sir, you
syllabus
can skip. You can
No, no,
skip, sir.
no, you can skip.
out of syllabus करके बोल देते हैं, no problem.
Yeah,
But some
there are
interest received on late payment of coal transit held before 22nd. But interest received, oh, okay. इनसे क्या नाम है, केशिका चौधरी, इनसे हम पूछते हैं अगर प्रोडक्ट इज एग्जेम्प्ट फ्रॉम जीएसटी तब इंटरेस्ट में क्या लगेगा रेट ऑफ टैक्स?
actually
Correct answer is interest received after 21st September, rate of interest will be calculated on the original tax rate payable. Sorry, rate of tax on the interest. Time of supply for the interest is now, okay.
Now,
But the supply is not treated as a separate supply. It's not treated as a separate supply. If you treat as separate supply, goods is attracted 0% tax. Interest separate supply usme time of supply interest. Oh, sorry. You are supplied an aloo, which is exempt of GST. The customer has delayed the payment of the consideration and he therefore pays interest to you. Do you pay GST on the interest? The rate of tax, interest is not a separate supply for the purpose of rate of tax. Interest received for delayed payment of consideration, time of supply alone is changed.
yes,
And is clarified, it will not be exempt as interest on loan. So,
yes.
levying tax on delayed payment of consideration is to ensure that the GST time of supply is different, plus it is not exempt as interest of loan. So, rate of tax applicable will be the rate of tax on the underlying supply.
Original sir.
Right. Yes, sir.
Keval,
yeah, sir.
somebody has raised the hand. I don't think she has asked the question. You want to allow her?
This was
Mithali
the
Parekh.
interest. This was the interest question, I believe.
Oh,
We can
okay.
unmute her, but
Mithali Parekh, she has raised the hand. Is it the same question or you want to ask something?
we've allowed her to talk.
What is the DRC? I want to reply as a partner.
Fine.
You close the matter. DRC 03. Somebody asked Sagar Desai. She had paid DRC 03. I agree. I assume DRC 03 means you accepted the content of the revenue and closed the matter by payment. Is it not so?
Yes.
So no show cause also issued. I don't know whether you can apply for a refund. Okay, under section 54. I do not know that. Okay. And if it is so, it is not treated as a matter pending matter, and therefore you will not be eligible for the benefit of this judgment. Okay. Right.
I think we can proceed, sir. She's not unmuting, so
Yeah,
we can
no,
move.
no issue.
Sahil sir, Sridharan sir, all questions here are done.
Very good. Raghav Gupta ji was unable to unmute. Yes, understood the doubt. No problem. Anything else? No.
Rajiv sir, over to you.
Yeah. One second, just a minute.
Any more questions?
No. Sridharan, the only thing is, since you have argued this
Oh,
matter,
somebody asked an entry tax, sir. Just see that. A question on entry tax. Let's have a look at it. What does he ask? 174
One
somebody.
I will share again.
Manish Sadeva, na? Keval Manish है there.
Umang, you
क्या
can
question?
unmute Manish.
दिखाइए question दिखाइए.
One
Is
second,
it there? Is Manish there?
Let me read the question, sir.
One second. I'll just share.
क्या question है साहिल?
Can you see, sir?
Yeah. Please throw light on the entry tax which in Haryana in the context repeal and constitutional way for context no rules were framed. Haryana entry tax was repealed. Section 174 of the Haryana GST except because entry tax constitution was omitted by this thing. Haryana government can frame rules in 22 hours. Okay. Pending. Huh? Pending. This issue is pending. Okay. And Sahil tells me that Lakshman sir are arguing this matter for the Punjab Haryana High Court. Okay, we'll see that. According to me, one small point, which is not directly relevant but still important. Many people make the mistake that because the repeal and saving clause, the old act continues even after the repeal. I repeat, many people think because repeal and saving clause under section 6 or 174 of the GST Act or whatever it is, the old law continues after the repeal also. That's a mistake. The old law is dead in this example on 30th June 2017. For the period prior to June 17, whatever rights and liabilities are incurred can be initiated, continued post July 17. Please don't assume as if repeal and saving clause continues the old act. The old act is dead. But for the past, liabilities incurred in the past, proceeding can be initiated, continued, and post this thing. Therefore, the power to frame a rule under repealed act is not possible. In the example, rules have been framed in 2024, okay, by under act which is repealed and by recourse to saving clause. Saving clause says whatever body of law is present on that day will continue. You cannot add or subtract to that. Okay. But sir, now vote of thanks and other things what you give, सात बज जाएगा.
Yeah. Sridharan sir, only one last question from my side. Just I have gone through the decision. There is a one observation noting further. It is stated in the present batch of petition, it was not even argued that the provision in Rule 89 4B and 9610 of the GST were not substantive provision affecting the right of importers and exporters. Then it is further mentioned that in any case, a review of these rules make it clear that they are not purely procedural but impact substantive right of the parties. Now, actually, I just want to know only one thing out of it. The refunds are concerned, the relevant section is 54. Whichever way you are exporting, the right comes through section 54. And these are all the procedure 96 that.
Not that. 96(1) may be the procedure. But the condition of 9610 puts a condition that is substantive. You will not get refund in this circumstance. That's what 9610 says.
Correct.
Okay. So
Correct.
that's a matter of substance. What was argued by the department was my GST Act continues, my section 73 continues, my section 74 continues.
Correct.
Rule आया जाए ना क्या फर्क पड़ता है? 9610 is there or not there? How does it make a difference? My demand is section 73. That section is remain unaltered. That was the argument.
Okay. Okay.
And then these rules are procedural. In that context, we said they put a substantive restriction on getting the refund. And those embargoes are removed now.
Okay.
Removed as if never. That was the context. That is one. Second, we say the contention. This is a similar contention raised before Gujarat High Court. That Central Excise Act remains. Only the rule for assessment is gone. Therefore, Rayala Court will not apply. The Supreme Court rejected it. Either the substantive section dies or assessment section dies. Either of the cases, revenue will fail.
Okay. Okay.
For revenue to succeed, both courts so coexist. In a case, charging section gaya, assessment section hai. Charging section hai, assessment section gaya. Okay. So, big farak nahi padta. Raj, why are you laughing at me?
Okay.
You are on mute.
Raj?
No, sir.
Hasrag is laughing or smiling?
No, sir, he's smiling. He's happy to hear you.
Okay, right. Thank you.
Thank you. Thank you, Sridharan sir. Keval, for vote of thanks.
Yeah, sir, thank you so much, sir. It was a wonderful session. Sahil ji, really, really thank you so much. Raj, over to you for a formal vote of thanks.
Thank you, Keval bhai. Good evening, everyone. Before I proceed to this pleasant and honorable task of proposing the vote of thanks, I would like to take a moment to announce the upcoming programs of the Indirect Tax Committee. There are two study circles one is on GST issues and non-profit organizations on 26 September and GST challenges and business closures and transition on 6th of October. These two study circles are there. We are doing one 6-hour workshop on practical use of AI in GST practice on 4th of October. The registrations are almost full. Only we are doing a physical workshop. So enroll for at the earliest. And our 14th RRC on GST at Agra from 8th of January to 11th of January 2026. So we invite all to actively participate in all the upcoming programs. Now to the task which have been given to express a gratitude to our esteemed speakers. First of all, I would like to say that great leadership is not measured by how many followers one has, but how many leaders one creates. And today, Sridharan sir has set a very good means example of having this creating a leader and his colleague. Also, my very dear friend Sahil Parghi. Thank you, Sahil, for the very structured and very nuanced presentation. You have explained all the legal points with all examples, case laws, and you have brought forward the very valuable perspective to today's discussion. And you are with very good freshness, you have explained all the nuances of the judgment. So on behalf of CTC, I would like to thank you. And now to my guru, I would Sridharan sir, and a guru to a lot of other professionals. That sir, your deep insights always remind you that you are one of the finest minds in tax jurisprudence in today's in today's times, and your clarity, your command on the subject is commendable, sir. Thank you. You are an ocean of knowledge, and thank you for sharing your knowledge with all the participants of indirect the CTC members of CTC. Thank you so much, sir, and thank you to all the participants. Thank you, Sahil. Thank you, Sridharan sir, and thank you to all the participants for joining today's session. We look forward to have you, sir, for further sessions also, and Sahil also. Thank you, all the participants. Thank you so much.
I only
Thank
wanted
you,
to have
Sridhar.
one sentence, only one sentence. What Sahil has done is remarkable because despite my interruptions, he was able to present neatly, which is not an easy task. I keep on interrupting. Okay. Thank you, Sahil. Thank you, Sahil. Thank you very much.
Thank you, sir.
Thank you.
Thank you so
Thank you.
much.
Thank you, Sridharan
Thank
sir.
you.
Thank
Thank
you,
you,
Sahil
Sridharan
sir.
sir.
Thank you very much. You'll be obliged, sir. Thanks. Shall we sign off now?
Yeah, we can sign.